road where they have these nice little things here? You know where there's, the cars have careened off the road and crashed and turned over and burned. They're called accident black spots. We call this evidence black spots. Why? Because we know, well, just like this thing here, which isn't working so well, that you have accidents. Let's see, is this going to work? Oh yeah, here we go. Look. That. Has anyone had any evidence problems in their real lives that end up looking like this? How about that? Have any of you have any cases that somewhere in the archives of your appellate reporters, there's a memorial to your attempt to deal with evidence? Anybody have one of those? Yes. And that's why we call this evidence black spots. So let's deal with them. All we're going to do in this very, very brief, brief discussion of evidence is talk about some of those areas that kind of torture people. Things that just cause us a little bit of problem. This is not evidence preparation for the bar. This is not an evidence class in law school. This is not an evidence CLE. This is just a quick overview of evidence black spots that maybe you can come away with just a little something that will make your life that much easier after today. Now, I have a question. Can everybody hear me? Can you hear me back there? Okay. Are we familiar with this one? Failure to object. This is probably the biggest one. What is the cause of the failure to object? Are we familiar with fear? All right? You're afraid. Objecting requires that you actually stand up, say the word object, and that you actually give a ground. And what is it that we're afraid of? What's number one thing that we're afraid of? Looking stupid. That harkens back to law school, where one of the great things we do, by the way, I teach at the University of Wisconsin Law School, so I actually am guilty of this, I think. I'm sorry. We actually drill into people that if they say the wrong thing, they're stupid. And that's where some of this comes from. We don't want to look stupid. We don't want to say the wrong thing. So rather than say the wrong thing, we say nothing. Oh, that's very worthwhile. Next thing, this one. I don't want the judge and the DA to be mad at me. I don't want the jury to not like me. I'll look like a bitch. Has anyone ever heard anybody give this as an excuse for why they don't object? I want to look good. And our mothers taught us that in order to look good, we actually are supposed to be nice and conciliatory. And we've again got it into our heads that if I stand up and say, objection, irrelevant, that somehow I'm looking like a bitch. And that is a bad thing. No. Big one. Almost all objections can be seen 100 miles away. When you go through your discovery, when you go through your investigation reports, when you go through your transcripts, whether it's grand jury, preliminary examination, or whatever it is, you'll see it. Well, that's easier said than done with this equipment here. Let's see if I can get it to go back. Nope. It won't go back. That's all right. What was those kids smiling, by the way? You know what they are? Have a good time. We're sitting here and we're telling you day after day after day here at NCDC. It's about storytelling. It's about having a great time. It's about enjoying your jury, enjoying your client, enjoying your case, and yet somehow, when we mention evidence, our jaws clench, our spines kind of tighten up, and we think, oh dear God, here's news. It's all of a piece. You want to talk about the record?
Sure. With the record.
Now, let's see. You know what? Where's the clip? Where'd it go? Let me deal with it.
Sure. If you don't make the record, you've waived it. We know this from all of our death work, from all of our appeals. With the record, you have to stand up. You have to say it. And guess what? Even if the judge overrules you, because he or she knows even less evidence than the prosecutor, who knows less than you, it is in the record, and you're telling the jury something about it. When you're, by standing up and saying, out of court, they aren't here, even if the judge turns from his summary judgment motion, you're letting the jury know what is wrong with it and why it's weak. It has to be timely. It doesn't make sense to do it the next day or to do it after the cat's out of the bag. It has to be done at that time. And you've got to stand up before the answer and preferably before the question. Correctly stated state and federal grounds. For those of you who only object on state grounds, if it goes to federal and you haven't constitutionalized it, that means talk about the Constitution, which, for example, Vice President Cheney reads differently from you and me. You have waived it. And for those of you doing capital habeas work, you know how frustrating it is. You have to object on state statutory grounds, state constitutional grounds, federal constitutional grounds. And if you don't, the courts are more than eager to say, oops, you didn't put it in the right pigeonhole. So you have to object timely, and you have to say the right one. And this may seem counter to what we were saying about this angst and this fear. Get up and say Constitution, or say there's something wrong with it, Judge. I'll supplement it later. But if you don't do that first step, it's bye-bye, and your client goes bye-bye. If you win, I know, a rare and wonderful thing, and they sustain it, you need to ask for a mistrial. What you say is, Judge, this is such a horrendous evidentiary a attempt by the government. The bell's been rung, the horse is out of the barn, all the little metaphors that we've taught you to use the past week. And we have to have a new trial, because once again, on appeal, if you don't, the courts of appeal will say, yes, there's error, but it was harmless. Or, gee, you know, the jury wasn't paying attention. So you have to say, this is very important, and here's why. And besides, it gives you something to say at the bench conference.
All right. This case was just decided by the Seventh Circuit. And Judge Cudahy, the most liberal judge on the Seventh Circuit, wrote this decision. It's terrible. If I had shot Munch's scream coming in here, believe me. What happens? Prosecution puts on somebody who is supposedly an agent of the defendant. Prosecution elicits testimony. What does Mr. Alleged Agent say? He says, X, objection, hearsay, admission by a party opponent, overruled. Boom. On appeal, defense said, this guy wasn't an agent. And if he's not an agent, then it's hearsay. Simple enough. Not good enough. Not good enough. This is why it has to be precise. Here's Judge Cudahy. Honestly, I mean, the Seventh Circuit, it's not exactly a bastion of liberal thinking, but Cudahy's pretty damn good. And we've got this. You didn't say the exact magic words, and because you didn't, it's not preserved, you lose. You lose. And You may be thinking this is contrary to the story and having fun concept of NCDC. It's all of a piece. But this is the careful preparation. Remember I said anticipation. You know, in this case, the defense saw this coming. This was not a surprise. So all this tells us is that in our preparation, you need to carefully orchestrate your objections and your response. It has to be as thoroughly prepared as your cross and as your direct. And if you need to script this, if you need to write this down, unlike your cross and unlike your direct, for God's sakes, write it down. Write it down. And have notes that circle. When a magic word is uttered, you will stand up, and here's my scripted line. And I'm going to have it all there. I think this case is extreme, but I think it's a good example of what you can expect out there.
It's not like you lose points for saying the wrong number. It's not like the judge will say, well, I will subtract this from the right ground. If you do a litany of the rules, it's a hearsay, it's not relevant, it's 403, and let's say that that it is relevant but not hearsay. It's not like the judge will say, well, because you made a mistake, you lose the whole thing. So you need to string it out. You can also tell the judge, I need a bench conference to explain it, or I need to supplement it, and the judge, who's always eager to move on, will say no, no, and then at least on appeal you can argue that they didn't give you a chance to make the record. But if the courts are going to play this game of gotcha, then we can play it too, and you can get this litany of the 4 or 5 big rules of evidence. The objections and the responses have to be consistent with your theme of the case. So this is more style. If, for example, in Bonnie Kitchens you are being warm and fuzzy and embracing, and yet when the state gets up and starts doing their case, and you come on like a pit bull, it is inconsistent with your theory. If in Dodd you are contemptuous of Judy and a wrench, but you treat them like a warm embrace, it is inconsistent. You have to realize that your objections, the jury is looking at you and wants you to be consistent with your overall theme. Now, you can make objections coolly professional or clinical. You can sound disappointed. You can be angry that the government has brought in this type of witness, but you've got to be in control of your emotions. You can't get the bit in your mouth and run with it. At all times, you have to know where you are and what your theory and the theme is. You have to appear confident. Never let them see you sweat. It helps if you appear knowledgeable. Just say 803. It's more than the judge usually knows. And once again, the judge has crisp, concise objections. This runs counter again to the trend to have these long, broad, cover all the bases. So what you need to do is say, Judge, I need to make the record. It's on these grounds, this Constitution, and here are the exact sites if you want it. If you can't think of the numbers, then say hearsay, out-of-court statement. But if you don't say it, you will be waiving it.
Right, right. And that's why, you get a sense where this takes practice. And we don't ordinarily think of this as taking practice, but if you've got a string cite objection, you can satisfy the crisp, concise objections step by saying, Your Honor, I'm objecting on 4 grounds. Number 1, number 2, number 3, number 4.
And this is a continuing objection.
Note it as a continuing objection. Depending on your rules, certainly if you've got to have a standing objection noted, do so. do so. But this tells you that this actually takes a little bit of study. You actually have to start to become fluent in the language of the rules of evidence, whether or not the judge is. The reality is, there's a lot of judges who don't know the rules of evidence. This may come as a shock to many of you. There are many judges for whom they are suggestions or guidelines. The more knowledgeable you appear, the more professional and well-packaged your objections, very frankly, the more likely you are to prevail, because you sound like you know what you're talking about. Here's some don'ts. Here's some real basic things. Just some real basic rules. Number 1, number 4, number 12, number 100 is please don't whine. Please don't whine. Your Honor, Your Honor, that's not, Your Honor. It sounds awful. It doesn't sound confident. It doesn't sound professional. It certainly doesn't sound like you know what you're doing. Don't whine. It's not personal. God help you, you'll be furious. You will lose on an objection or some kind of evidentiary ruling that you should win on. If you haven't yet, I admire you. I don't know how you've gotten this far. But I'm telling you, your blood pressure will climb and you're going to have blood coming out of your eyes. And it's not going to show. This isn't where it shows. Do not ever turn to the DA and say something to them. You will want to. I'm sick of you. Don't do it. Don't do it. And this thanks the judge. This is from John and herself. You know, you win, it's bad enough. Thank you, Your Honor. But you lose. Thank you, Your Honor. Don't thank the judge. This is business. The judge isn't doing you a favor. And they're really not doing you a favor when you lose. Thank you, Your Honor. I mean, it's this thing from our parents. Stop it. Stop it. So don't thank the judge. You want foundation?
Foundation is really simple. It means this is why the jury should believe the piece of evidence. There's no legal magic wand that you need to wave. There's no magic word. What you're doing with foundation is you're telling the jury, you should believe this witness, or you should accept this piece of evidence as credible because the witness says he or she knows it. That's all. It's not like you're going in there and say, does this photograph accurately reflect the time of the place, and does it look the same? You are saying, does this photograph look like it did then? Did you take it? When? That's all. You're speaking English. And you're doing it with a witness so that he or she becomes interesting. You're bringing on these witnesses to lay documents or evidence, show that the witness is there for a reason and that he or she is an integral part of the case. Let's say that you have to bring in custodians of a record. Usually they come in there, they are bored, the jury has sat through the state's case and got through their custodians of records. Yours are interesting. Ms. Mabel, how long have you worked at the Department of Motor Vehicles? What is your day like? What are the records like? Has there been a revolution with the internet? And, it's really not relevant, but it's interesting, and you're engaging, and they would give you things, and then it's like these documents are actually important because you are spending time with the witness. If you are engaged with the witness, the jury will engage with you. And for the custodian of records, sometimes this is the highlight of their year. Think about this. Coming into your court and doing these business records is like an exciting thing, and you can share that with them. With custodians of records, with people bringing in things, engage them, make them interesting, and the jury will think that you are interesting. When you stand up, it will be important. And of course, use English. Do not use the legalese that from the interview.
Right, right. I mean, and the reason, John and I were talking about this, is how many times have we seen foundation get laid where somebody's on autopilot? Now I'm in the foundation portion of this particular witness. That's what we're talking about when it says your affect has to match the substance not only of this witness and this piece of testimony, but of the case in general. Don't go into autopilot. You should never, ever be an autopilot. All right. What's fascinating to me is that the older I get, the more frustrated I get with judges' inability to understand what this stuff is. I'm getting, the act professional is getting harder and harder and harder. I do believe that several weeks ago I was called for rolling my eye. The fact that somebody says something outside of the courtroom, off the witness stand, does not necessarily make it hearsay. And the fact that the DA objects that it's hearsay doesn't make it hearsay. So this is a little refresher. That's hearsay. That's what hearsay is. If I step outside and say, "Good Lord, it's hot outside," and somebody later comes in and says, "Michelle said, 'Good Lord, it's hot outside.'" The fact that I said it and someone else is saying I said it doesn't end the inquiry, and this is what makes me insane. It makes me insane. What is it being used for? If it's being used to show that it's hot outside in Macon, Georgia in the last week of June, then probably it's hearsay. But if it's being used to show that Michelle was here, then maybe it's not. And if Michelle walked outside in Madison, Wisconsin on January 12th and said, "Good Lord, it's hot outside," it's either being used to show maybe global warming or that Michelle's crazy. That's all. A few months ago, I actually had a lawyer on the stand. We're talking about his dealings with a witness. I said, "Question, did you ask him about such and such?" Objection, hearsay. I mean, this was my response. I said, "Your Honor, this is being used for a non-hearsay purpose. It is not being used to show the truth of the question. It's being used to show what elicited the particular response." You know what I got? "Well, counsel, I'm not as sophisticated as you people at the University of Wisconsin, but I'll allow it in the catch-all reliability section, hearsay exception." Fine. Call it whatever you want. You're holding this. Okay, fine. But understand this is what I'm dealing with. Okay, how do we say this? If we're putting in something that is not used to prove the truth, what does this look like to a jury? Come up with another way. The best way I've come up with, this is being used for a non-hearsay purpose. This is being used for a non-hearsay purpose. And stay away from the word truth. If they say, "What do you mean, counsel?" you could say, "It's not being used to show the truth and falsity of that comment. We are not being asked to believe or disbelieve the comment. It's being used, but non-hearsay purpose will get you there. Non-hearsay purpose is my personal favorite. Use it. All right. in hearsay, and it's big when we are making our objections. All right. We object to something as hearsay. State objects, it says it's being used for a non-hearsay purpose. The fact that if it's a non-hearsay purpose, that non-hearsay purpose has to be relevant. If they say it's not being used to prove the truth, it's being used to show the state of mind. Well, then the state of mind of the declarant had better be relevant. The mere fact that it clears hearsay does not make it admissible. Relevance is always relevant. Same thing. I love this. Objection. You got hearsay, or you say objection irrelevant. Well, this is an exception to the hearsay rule. It's admissible as an exception to the hearsay rule. But it's got to be relevant. The mere fact that and I think part of that has to do with the unbelievable size of hearsay and its 9 billion trillion exceptions. It sits out there, and so we start to believe, well, if we clear hearsay, either because it's not hearsay, it's an admission of a party opponent, or it's coming in under an exception, it must therefore be admissible. No, it's not. It has to still be relevant, and that's why it says relevant is always relevant. Leave us not forget, just because something is admissible under 403 or under hearsay as an exception, as a non-hearsay, we still have to deal with 403. Just like you have to deal with relevance and whether something's relevant or not, you've got to deal with the probative value versus the potential for unfair prejudice. That's always there. Hearsay is not the end of the story.
Crawford is not a rule of evidence as much as it is a rule of criminal procedure. What the Supreme Court did with Crawford was say that there are some rights, some procedural rights that are so important that we aren't going to use a balancing act. Crawford overrules Ohio v. Roberts, which was sort of the catch-all that judge got to weigh and balance the strength of the hearsay exception for a strict categorical approach, for a line drawing. Crawford was a case, as many of you probably know, in which a husband was told by his wife that the wife was sexually assaulted. They decided to go and confront the person, possibly for a date on the Jerry Springer show. Bad things happened during this little confrontation, and later the police come and speak with the wife. The wife says that she may not talk, but they pressure her. She gives statements, and later she takes it. She invokes the marital privilege. The state brings it in under the catch-all exception, and the Supreme Court says, no, enough of Ohio v. Roberts. The importance of the confrontation clause is that you get a chance to confront the witness in this situation, that you get a chance to look them eye to eye. And so it supplants, it goes on top of the rules of evidence, and you're drawing this procedure. It becomes a rule of criminal procedure. Judges are having a hard time dealing with this, but what you need is the statements that are effective by it have to be made to a police officer or in an investigation context, and it has to be with an eye toward litigation or to a court. So with Crawford, what you have is you have the evidentiary basis that the state or the prosecutor has to meet, and then you have to say, is there a confrontation clause? Do I get a right to stare at the witness? the Supreme Court carved out some old common law exceptions with co-conspirator and the mission of a party opponent, but under modern day, the government state has to bring in that witness.
Okay. All right, this stuff drives people crazy. Prior bad acts. Under 404. However, John, fear not. I mean, we tend to be afraid of it because, very frankly, it tends to be used against our client. However, it isn't prior bad acts, by the way. It's prior acts, right? Prior acts. It can be a sword. It can be a shield. It can kill you. Make no mistake about it. It can just put you right, pierce your case right through its little heart, twist it, and then put it on, put it on the grill as a kebab. That's all that's going to happen. But it can help you. It can help you. Take a deep breath. What is this stuff being used for? Always ask yourself, why is it being used? What is it that they want to do with this stuff? What's the point?
And it's just not you asking. The state has to say what it's using for. There may be a reason that is legitimate, but if the state doesn't identify it, sauce for the goose, sauce for the gander, they have to say exactly what it's being used for. If it's to prove motive, then it has to say it, and it has to be a specific intent often. If they muff it up, you can catch them on it.
All right. 404, if it's being offered for a purpose, a 404B purpose, is it relevant? Motive may not be relevant. Intent, I love this, identity. Identity, this is a self-defense case. All right, it has to be relevant. That which they say they are using it for has to actually be in issue in this case. The one exception, at least in my state, is child sexual assault cases. In which case, it doesn't matter what the case is about, it's coming in. I promise you, the eased rule of admissibility in child sexual assault cases, as they call it, according to the great Supreme Court of Wisconsin. If you got that, it's slightly different. But otherwise, the mere fact that they can identify a purpose under 404B, or your state's version, does not make it admissible. That has to be an issue. It actually has to be relevant. Remember under 405, proof of instances of conduct. This is real helpful to us in self-defense cases. Remember, if it's an essential element of your claim, in self-defense cases, we can get in many of the prior bad acts of the alleged victim, right? This is when we get to use it. We get to take the sword and use it ourselves. And even though you're being bludgeoned to death with 404 and 405 testimony, don't forget 403. That the probative value is outweighed by the potential for unfair prejudice. That rule never, ever, ever goes away. It is always there.
It may be a situation in which the court won't keep out all of the photos, but it would keep out 150 of the 200. So you can deal with ones that you have. And a sidelight to this is Rule 806, which is impeaching a declarant of a co-conspirator. If it comes in, if hearsay comes in, and there's a hearsay exception, you can impeach the out-of-court declarant just as if he or she were there.
Don't forget this. We have a tendency to think that 404 and 405 are only against us. We get to use them too. They can actually be very, very useful things. Don't be afraid to make them your own. Don't be afraid to be filing that motion that says under, our version of 404 and 405, I'm going to put the following 6 things in. Go for it. There is nothing in there. You look at the rule, there's nothing in there that says this is to be used by prosecutors only. You get to play with it too. You get to share the toys. So, please. Quickly, this should be 609, for which I apologize. And this is an interesting question. It's the prior convictions. What are we doing when we're talking about this business of prior convictions under 609, not under 404, under 609? We're saying you, witness, are a liar and less worthy of belief. Very different than under 404 and 405, in which we are saying there is something about my case or their case that makes it less or more likely to be true. This is just saying, you, scumbag, are a liar. All right, how does this work? And this is such an interesting question that came up today. It's an out-of-court determination, and it's a fake number in the sense that it's governed by the rules in the federal system. You know, it's your 10-year rule having to do with honesty. Wisconsin, it's wide open. It's whatever the judge thinks is admissible. It's a fake number. Your client may have 9 prior convictions, but the number that's going to come up, having been convicted of a crime, answer 4. It's an artificial number. Now, some people are saying in some other jurisdictions this is different. It is a limited inquiry. My understanding of the rule, John's understanding of the rule, is the question goes like this. Have you been convicted of a crime before? Answer, yes. How many times? 4. And if it's this, it's under 609. It could be an identical crime, and under 609, they're not asking it. Now, people get this confused with 404 all the time. If your client is up on the stand, and there's a ruling that the guy's got 4, you can put it in. You can put it in by asking, have you been convicted of a crime? How many times? 4. It's over with. It's over with. You can, if you want, go further, but God help you. You start because you want to say the answer is, say, 2, and they happen to be something so radically different. You could have problems. And of course we know that if your client gives a lower number than that which was determined by the judge, well, you might as well just go out and get a sandwich and come back, because the cross-examination will take days to fill this in. This is a very limited inquiry. And you need to make the determination. What is it that's being used? Your Honor, the state wants to use 2 prior convictions. You want to battle it out till you get it down to 1, and then you want it abundantly clear. They don't get to say whether it's a felony or misdemeanor, at least where I live. And they don't get to say what it is under 609. They don't get to go into that. So please, 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 this is a huge area of problem.
It's a bit more expansive, but you don't get into the facts of the case or whether there was circumstances. It's basically the length of the sentence, what it was, and when it was. But none of this, what the facts were.
Why is this going this way? Let's see. Now, there we are. Okay, we'll complete it. That's yours.
So,
yes.
Rule of completeness, if the government uses a statement, state uses a statement that's out of context, you have the right to complete it, to bring in the unit that explains it or places it in the context. So this comes a lot in statements by the defendant. I was at the bank on this day. Well, the other statement was I had just dropped off my girlfriend who was going to work, so he couldn't have been there at the time. You get to put in that statement, so you get to complete it. The state and government is very good about cherry picking, but you have the right to fill in, to put in the complete statement and put it in context.
All right. All right, expert witnesses. This is real easy. All right? Anybody's an expert in something. In something. What it is, the trick is, lay the foundation, just like John said. For the witness, this is the most interesting person on the planet. They know something, they're worldly wise, they've studied it, and they know something you don't know. That's the foundation. And then foundation for the topic. Make it interesting. I don't care what it is. I don't care how extraordinarily dull it is. If it's the blood alcohol curve, I don't care. It's the most interesting thing. That is foundation. Final rule. Have some fun. At the same time, you got to pay attention. This is one, you got to anticipate what's coming. You've got to stay in control. When you have, if you have an evidence notebook, tabs on every single thing that tells you, now's the time. You cannot figure out evidence when you walk in there and say, oh, I'll get it as it's coming to me. I mean, maybe you can because you're smarter, a lot smarter than I am, because I can't. There's too much information. I got way too much information to try to deal with. It asked me to then say, and in addition to listening to these witnesses and seeing how your cross is shaping up and paying attention to the story and watching the jury and making sure my client's not throwing up over here, by the way, start thinking about evidence too. I can't do it. I can't do it. But if you think ahead, if you prepare, if you always have that little corner of your mind that's going evidence, and you have your little sticky notes down your sleeve to say, here's the things that I got to deal with, you will love it. You will love it as much part of storytelling as anything. You got any questions?
Yeah, can you go one screen back?
Yes, sir. I can try.
Oh no, it's too late for taking notes. Please.
Are you taking notes? Hang on a minute. I'll get you there. There you go. How's that? Come on. Let me know when you're done. All right. But the point being, just prepare. Think of it. Start thinking technically. Think of it as this is some of the technical stuff that holds up your story. It's as much a part of the trial as the fun, sexy story stuff, and you can have some fun with it. Now what you get to do is take 3 minutes, take a break, because you're going to come back. And who's going to be back here? Us!
But it will be fun. This will be the fun part.
This will be fun, we promise.
No notes, toys.
Yes.
Lots of toys.
Yes, put your pens down. Here's the way.
Monday's a hard day. Out of being in shape. By the end of last week, being in shape and working all day, and had the weekend. I